Usually when we think about the law, and especially the United States Constitution, there's this, like, deeply ingrained expectation of permanence.
Right, absolutely. We treat it like it's carved in stone.
Exactly. Like, you look at a legal text, you apply it to a situation, and you get an objective answer. It feels comforting, it feels stable.
It does. It provides a sense of security.
But then you look at the year 1896. In 1896, the United States Supreme Court ruled in a case called Plessy v. Ferguson that racial segregation, specifically in, like, railroad cars, was perfectly constitutional under the 14th Amendment.
And that was a 7-1 decision, right?
Say 7-1. The court looked at the amendment guaranteeing equal protection and basically said, yes, separating people by race is entirely compatible with this.
Which is wild to think about today.
It is. And then you fast forward to 1954, you have the exact same Supreme Court, as an institution, interpreting the exact same 14th Amendment, but this time ruling unanimously in Brown v. Board of Education that segregation is inherently unequal.
And therefore unconstitutional.
Right. Same foundational document, same institution. Two entirely different legal truths.
Yeah, it forces us to confront a very uncomfortable reality about our legal system. We like to think of the court as existing in this vacuum of pure logic, where justices just solve legal equations.
Like math.
Exactly, like math. But these two cases, separated by just over half a century, they completely shatter that illusion. The parchment didn't change.
Right.
The words equal protection of the laws didn't change at all. So the variable in that equation wasn't the law, it was us.
Okay, let's unpack this, because if the words on the parchment didn't change between 1896 and 1954, we have a monumental mystery on our hands here.
We really do.
So we're going to spend our time today exploring a massive, honestly incredibly detailed historical framework laid out by scholar Michael J. Klarman. It's in his work, From Jim Crow to Civil Rights.
It's a fantastic, really dense piece of historical analysis.
It is. And we are going to trace the hidden, often shocking mechanisms that literally flipped the Supreme Court upside down over 50 years. We're doing a deep dive into 3 big questions for you today. First, why did American racial attitudes actually change so drastically between 1900 and 1950?
Which is a huge question on its own.
Huge. Second, what truly explains judicial rulings like Plessy and Brown if they aren't just, a strict reading of the text? And finally, does the Supreme Court actually drive social change in this country, or are they just riding shotgun to history?
Right. And to set the table for this, we need to view this history without the lens of mythology. When we look at the historical record provided in the source material, this isn't a story of heroes in black robes coming down from the mountain to save the day.
Nor is it a story of cartoonish villains, right?
Exactly. The history here, it doesn't prescribe how judges ought to act or pass moral judgment on their philosophies. It simply looks at the cold, hard facts of how the intersection of law and politics dictated the struggle for racial equality.
So it's very analytical.
Very. We are examining the demographic, the economic and geopolitical forces that pushed the nation, and how the court merely responded to those overwhelming forces.
Right, and to understand that response, to understand this massive shift from Plessy to Brown, we have to, open up the hood of the Supreme Court and look at the actual machinery of how a justice makes a decision. Because it clearly isn't just a math equation.
No, not at all. There are essentially 2 dominant schools of thought in legal scholarship regarding judicial decision-making. The first is formalism.
Formalism, okay.
Yeah, this is the orthodox view. It argues that judges simply apply the text of the law, the original intent of the framers, and pass legal precedents. In its most extreme version, a judge is just a highly trained technician.
Right, they just read the manual.
Exactly. They lay a statute next to the Constitution, see if they line up, and declare a winner.
The umpire calling balls and strikes.
That is the popular metaphor, yes. But then the competing school is realism, sometimes called attitudinalism.
Attitudinalism, that's a mouthful.
It is. But this theory argues that judicial decisions are primarily driven by a judge's personal values, their politics, or, well, the dominant social views of their time. The most cynical, crude version of this theory jokes that a judge's ruling depends entirely on what they had for breakfast that morning.
Wait, if it's just what they ate for breakfast or, what their country club friends think, why do we even have a constitution?
That is the big question.
If the court just follows whatever the public opinion is on a given day, aren't they failing their core job? Isn't the entire point of a constitutional court, with lifetime appointments and all that, to protect the minority from the tyranny of the majority? If they just bend to the wind, they're kind of useless.
This raises an important question, and that tension is really the central problem of constitutional law. To resolve it, the historical framework we are exploring proposes a synthesis of these two schools.
Okay, a synthesis. How does that work?
Think of every Supreme Court decision as existing on a graph with two intersecting axes. First, you have the legal axis. This consists of the text, original intent, and precedent.
Got it.
This axis ranges from highly determinate, meaning the law is crystal clear, to highly indeterminate, meaning the law is ambiguous.
Give me an example of something crystal clear on that legal axis.
Okay, the Constitution says the president must be at least 35 years old. That is highly determinate. No matter how much a judge might personally want a 30-year-old prodigy to be president, the legal axis is so strong it overrides personal preference.
Okay, that makes sense. It's a hard rule.
But then you have the political axis.
Oh.
This includes the judge's personal values, the broader social context, and external political pressures. This axis ranges from weak preferences to very strong preferences.
So when the law is a concrete rule, like the age of the president, formalism wins. They follow the rule. But when it's fuzzy, realism takes over.
That is the dynamic, exactly. When the law is determinate, judges generally follow it unless they have incredibly strong, overwhelming personal preferences to the contrary. But when the law is indeterminate, as it very often is, with sweeping, vague phrases like due process or equal protection of the laws.
Which could mean almost anything, depends on who you ask.
Right. When it's vague, the political axis becomes the deciding factor. And here is the vital reality to grasp. Judges are intrinsically part of contemporary culture. They occupy a very specific, elite subculture.
They aren't living in a cave.
No, they are highly educated, relatively affluent, deeply connected individuals. They rarely hold views that deviate drastically from the dominant public opinion of their era, particularly the opinion of their peers.
Right.
People treat the Supreme Court like a thermostat. They think it sets the temperature of the country. But the historical data suggests it is actually a thermometer. It only registers the temperature the country has already reached.
A thermometer, wow. That makes total sense. But it also, it strips away a lot of the romance we have about the justice system.
It definitely demystifies it.
Yeah. To really see this thermometer in action, we have to look at one of the darkest readings in American legal history. Let's head to the 1890s and the lead up to Plessy v. Ferguson.
A very dark period, yes.
Right. So imagine you're living in the Deep South in 1892. The optimism of the post-Civil War Reconstruction era is completely dead and buried.
Long gone.
The federal troops are gone. Southern black voters, who had actually elected hundreds of black office holders in the 1870s and 80s, are being systematically, ruthlessly disenfranchised.
It was a period of severe aggressive regression. Around 1890, race relations in the South began a steep downward spiral. States were holding new constitutional conventions specifically designed to adopt poll taxes, literacy tests, and grandfather clauses.
Basically any trick to suppress black voting.
Exactly. At the same time, political demagogues were rising to power by preaching unrestrained white supremacy to poor white farmers.
And what was the goal there? Just pure racism?
Well, the explicit political goal was to disrupt any potential cross-racial class alliances between poor whites and poor blacks. They didn't want them teaming up. And enforcing all of this was a campaign of domestic terror.
Lynchings.
Yes, lynchings were averaging over 100 per year in the United States during this decade.
It's just horrific. And right in the middle of this suffocating atmosphere, the state of Louisiana passes a law in 1890 requiring railroads to provide equal but separate accommodations for black and white passengers.
Which sets the stage for Plessy.
Right. Now, most people think Homer Plessy just got on a train one day, sat in the wrong car by accident, and got arrested. But the historical record shows this was a highly orchestrated, incredibly risky test case.
It was practically a sting operation.
Yeah. A citizens' committee of upper-class Afro-Creoles in New Orleans organized to challenge this segregation law. They hired Albion Tourguy, a famous civil rights lawyer, and they deliberately recruited Homer Plessy as their plaintiff.
And why Plessy, specifically?
Well, because he was of mixed heritage, 1/8 black, according to the legal parlance of the time, and he appeared white to the casual observer.
What's fascinating here is the coordination of this event. The Citizens Committee actually conspired with the railroad officials to ensure Plessy was arrested.
Wait, they conspired with the railroad?
Yes. Because Plessy appeared white, a conductor wouldn't have naturally challenged him. The arrest had to be staged.
Which raises a huge question. Why on earth would the railroad company help coordinate the arrest of their own passenger? Why would they want to be sued?
From a purely corporate capitalistic standpoint, the railroads despised the segregation law.
Oh, because of the money.
Exactly. It was an unfunded mandate. It was incredibly expensive and logistically frustrating to attach and maintain separate rail cars for different races, especially on routes that didn't have many passengers.
So they just wanted to run their trains efficiently.
Right. They wanted the law struck down just as much as the Citizens Committee did, strictly for the sake of their bottom line. But as this meticulously planned case wound its way through the appeals process to the Supreme Court in the mid-1890s, the social climate was rapidly deteriorating around them.
The temperature of the country was dropping fast. Which brings us to 1896. The court rules 7-1 against Plessy. They uphold segregation. They invent the doctrine of separate but equal.
A devastating blow.
If the court is a thermometer, we have to ask why the entire country, and I mean including the North, was suddenly perfectly fine with this level of systemic oppression. We always blame Southern racism, but the North was deeply complicit here, weren't they?
Absolutely. The North essentially abandoned Southern Black Americans, and the extra legal factors driving this abandonment are crucial to understand the thermometer.
What were those factors?
First, you had Northern migration. As more Black Americans began migrating to the North, racial prejudice among Northern whites escalated. They started experiencing the demographic shifts themselves.
Ah, so it wasn't just a Southern issue anymore.
Right. Which led to increased discrimination and even the creation of segregated schools in several northern states. They lost their moral high ground because they were adopting similar prejudices.
But it goes even deeper than domestic migration, right? There is a massive foreign policy angle here that blew my mind when I read it. American imperialism.
Yes, the imperialist era. The late 1890s saw the Spanish-American War. The United States annexed the Philippines, Guam, Puerto Rico, and Hawaii.
Suddenly we have an empire.
Exactly. Suddenly, the U.S. was acquiring overseas territories populated by millions of non-white people. Imperialists in the North began adopting this paternalistic, white man's burden mentality. They overwhelmingly rejected the idea of giving full constitutional citizenship and voting rights to the populations in these new territories.
Talk about a glass house scenario.
Yeah.
You can't throw stones at the South when you're doing the same thing abroad.
It was an inescapable hypocrisy. Northern politicians and intellectuals found it completely untenable to criticize Southern white politicians for disenfranchising Black Americans in Mississippi, while they themselves were busy denying basic rights to newly conquered populations in Manila.
Wow.
The imperialist venture demanded a racial hierarchy, and that hierarchy validated the South's Jim Crow system.
And on top of imperialism, there's the Civil War reconciliation piece. The North and South had just spent decades hating each other, hundreds of thousands dead. They finally wanted economic peace.
They wanted to move on.
Right. They wanted national unity. They bonded over fighting side by side in the Spanish-American War. And the political price for that reunion was looking the other way on civil rights.
A terrible compromise.
Yeah. I mean, the Republican Party, the party of Lincoln, the party that fought the Civil War to end slavery, essentially dropped their commitment to black suffrage. They realized the electoral math had changed. They could maintain national control without needing Southern black electoral support, so they just let the South do whatever it wanted.
So if we plot this on our graph, the political axis in 1896 was overwhelmingly weighted toward permitting racial segregation. The national consensus, forged by imperialism, reconciliation, and Northern prejudice, demanded it.
Okay, so the political axis is screaming segregation. But what about the legal axis? We might assume the court had to twist the law into pretzels to allow segregation, right?
You would think so, but the historical reality is much more sobering. Legally speaking, Plessy wasn't a massive stretch for its time.
Wait, how is that possible? The 14th Amendment literally says equal protection. It's right there.
It does say that. But when a formalist judge looks at the original intent of the Congress that drafted the 14th Amendment in 1866, they find intense ambiguity regarding social segregation.
Really? Ambiguity.
Yes, that Congress was entirely focused on securing fundamental civil rights for freedmen, like the right to own property, to make contracts, to sue in court.
The basics of existing in society.
Exactly. But the vast majority of Northern whites at that time did not support social integration. In fact, the very same Congress that wrote the 14th Amendment simultaneously voted to segregate the public schools in the District of Columbia.
You're kidding. The same Congress.
The very same. So if you're a Supreme Court justice in 1896 and you look at the legal axis, the text is vague, the original intent seems to tolerate segregation, and state court precedents are upholding it left and right.
Wow.
Then you look at the political axis, and the entire country is screaming for racial separation. You don't have to be a cartoon villain to rule against Homer Plessy. You just have to be a perfectly ordinary product of your time.
To have ruled in favor of Homer Plessy in 1896 would have required an almost unfathomable act of judicial heroism then. It would have meant standing alone against the overwhelming dominant public opinion of white America.
And judges, as institutional elites, are rarely vanguard revolutionaries.
But they didn't just uphold segregation in train cars, did they? The court actively, though quietly, crushed black rights through procedural manipulation. They used something called subconstitutional rules.
Yes, subconstitutional rules.
This is a dense legal concept, but it is terrifying in practice because it's basically an intentional legal maze. Walk us through how they use this.
We have to look at jury discrimination to understand this mechanism. In an earlier case from 1880, Strouder v. West Virginia, the Supreme Court actually ruled that a state could not pass a law explicitly barring black men from serving on juries.
Okay, so that sounds like a win.
Right. A law that said only white men can serve was a clear, undeniable violation of the 14th Amendment. So in the 1890s, Southern states adapted. They didn't explicitly ban black jurors by statute anymore.
They found a loophole.
A big one. Instead, they passed laws giving immense, unchecked discretion to local jury commissioners to select men of good moral character.
Let me guess how that went.
Naturally, these all-white commissioners simply never selected a single black citizen.
So the law on the books looks perfectly fair, perfectly race neutral.
Yes. And when black defendants appealed their convictions to the Supreme Court, arguing that the juries were clearly segregated in practice, the court faced a dilemma. They didn't want to overturn Strouder. That would look too blatantly racist.
So what do?
Instead, they manipulated subconstitutional rules, specifically the standards of proof and the scope of appellate review.
They rigged the game?
They did. They required the black defendant to prove that the jury commissioners had intentionally discriminated against them based on race.
Which is impossible to prove. You can't read their minds.
Exactly. But simultaneously, the Supreme Court deferred heavily to the state court's findings of fact. If a Southern trial judge said, well, the commissioner testified he didn't discriminate, he just couldn't find any qualified black men, the Supreme Court would say, well, we must trust the state court.
That is so cynical.
They maintain the facade of constitutional equality on the surface while accommodating the regressive racial climate through impossible procedural technicalities.
It's a bureaucratic dead end.
Yeah.
You have the right to a fair jury, but the court sets the standard of proof so high that you can never actually prove your rights were violated. So what does this all mean? It means the court in the Plessy era was perfectly seamlessly aligned with a racist America. The thermometer was registering freezing temperatures.
And that fortress of Jim Crow remained seemingly impenetrable for decades.
But fortresses only hold if the ground beneath them is stable. And as we move into the interwar period, 1920s and 30s, the sheer undeniable brutality of Southern justice started causing earthquakes that even this highly conservative Supreme Court couldn't ignore.
Things started to shift.
We start seeing a crack in the wall. Not because society suddenly became enlightened, not because the justices read a sociology textbook and changed their minds about race. The cracks formed because the abuses in the South became so utterly, cartoonishly grotesque that they offended the basic procedural sensibilities of the elite legal class.
That's a great way to put it. The interwar period features a series of landmark criminal procedure cases. The Supreme Court started handing down unprecedented, almost shocking victories for black defendants.
But we have to be clear, right? They didn't do this by striking down segregation or voting restrictions.
No, not at all. They did it by stretching the Due Process Clause of the 14th Amendment to stop what were essentially legal lynchings.
The facts of these cases are just harrowing. I mean, imagine you were in Phillips County, Arkansas in 1919. This is the setup for Moore v. Dempsey, decided in 1923.
A very tragic event.
Black sharecroppers, who were being violently exploited financially, gathered in a church for a union meeting to demand fair payment for their cotton. A white posse fired into the church. The sharecroppers fired back. In the ensuing chaos, which became the Elaine Massacre, white mobs and federal troops killed potentially hundreds of black people.
And the legal aftermath was just as horrifying.
Right. After the massacre, dozens of black men were rounded up and put on trial for murder. The trials were a mockery of the judicial system.
They lasted less than an hour.
An hour for a murder trial.
The defense attorneys didn't call any witnesses and didn't even ask for a change of venue. The juries deliberated for a matter of minutes before handing down death sentences.
Just a conveyor belt to the executioner.
And throughout the entire proceeding, an armed lynch mob was literally surrounding the courthouse, making it explicitly clear to the jury and the judge that if death sentences were not delivered, the mob would take the prisoners and lynch them in the street.
Prior to this, the Supreme Court had heavily deferred to state courts on criminal matters. State sovereignty was paramount. But here, they intervene. They finally step in. They rule that a mob-dominated trial is not actually a trial at all. It violates the Due Process Clause.
And this pattern continues. In 1932, you have Powell v. Alabama, known universally as the Scottsboro Boys case.
Very famous case.
9 young black men were falsely accused of raping 2 white women on a train. They were rushed to a capital trial in a highly volatile atmosphere. The judge didn't appoint them adequate legal counsel until the very morning of the trial.
So no time to prepare a defense at all.
No time to investigate, no time to prepare. The Supreme Court reversed their convictions, establishing for the first time that in capital cases, the state must provide effective counsel for indigent defendants.
And the darkest one might be Brown v. Mississippi in 1936. A white farmer is murdered. The local deputy sheriff rounds up several black suspects. And we aren't talking about a coerced interrogation here. We are talking about literal medieval torture.
The details are very difficult to read.
The deputy sheriff admitted on the witness stand that they hung one of the defendants from a tree, let him down, hung him again, tied him to a tree, and whipped him until he confessed. They laid other defendants over chairs and whipped them with buckled leather straps until their backs were shredded.
And the convictions were based entirely on these torture-induced confessions.
Completely. When the case reached the Supreme Court, the state of Mississippi actually argued that under previous interpretations of the Constitution, the federal government had no right to dictate how a state ran its criminal trials, even if it involved coercion.
The audacity of that argument is stunning.
It is. The Supreme Court rejected that horrifying argument, ruling that a conviction based on physical torture fundamentally violates due process.
But here's the critical analytical point we need to look at. Why did the court step in here in these specific criminal cases, but nowhere else? Why save the Scottsboro Boys, but ignore the millions of black people denied the right to vote?
Yeah, what's the disconnect there?
It comes down to a clash of paradigms between Southern state judges and the Supreme Court justices. Southern state judges at the time operated under a very specific, deeply cynical worldview.
Which is what?
They viewed any formal trial, even a sham trial lasting 45 minutes with a bloodthirsty mob outside, as a progressive, civilized step up from a literal lynching.
Oh, wow. So they patted themselves on the back just for being in a courthouse.
Exactly.
Yeah.
They thought providing the veneer of a courtroom was enough. The Supreme Court justices, however, residing in Washington and steeped in elite legal traditions, operated under a different paradigm.
Right.
They believed the actual functional purpose of a criminal trial was to determine objective guilt or innocence through a fair adversarial process. They could tolerate segregation, they could tolerate disenfranchisement, but they could not tolerate a courtroom being used as an open, bloody theater for a mob.
They were offended as lawyers.
Precisely.
It's like a doctor walking into a filthy hospital. They might not care about the poverty outside the hospital doors, but they care deeply if the surgeon is operating with dirty hands. They wouldn't touch Jim Crow segregation, but the sheer brutality of these cases offended their institutional pride.
Exactly that. By highlighting the absolute worst, most barbaric features of white supremacy, these egregious cases forced the justices to rethink their previously tolerant attitudes towards Southern justice. And during this same interwar period, we also see the very first tactical crack in the facade of segregated education.
Right. Specifically in the 1938 case, Missouri ex rel, Gaines v. Canada. This is a brilliant piece of legal strategy. Walk us through Gaines.
So Lloyd Gaines was a black student who applied to the University of Missouri Law School. Missouri was completely segregated by law, so they obviously rejected him.
Right.
But Missouri had a problem. They didn't have a separate black law school. So their separate but equal solution was to say, hey, we'll pay your tuition to go to an out-of-state law school in Illinois or Iowa that accepts black students.
Enter Charles Hamilton Houston.
Yes, the legendary architect of the NAACP's legal strategy.
He doesn't argue that segregation itself is illegal, does he?
No, and that's the genius of it. He argues that Missouri isn't holding up its end of the separate but equal bargain. Houston understood the formalist constraints of the court. He didn't ask them to overturn Plessy. He asked them to enforce it strictly.
And what did the court say?
The court agreed with Houston. They ruled that Missouri's out-of-state scholarship ruse violated the Equal Protection Clause. The state had a constitutional obligation to provide equal educational opportunities within its own borders. Missouri couldn't outsource its constitutional duties.
So Missouri is forced to either integrate their white law school or build a brand new, fully functioning black law school from scratch, which is impossibly expensive.
Precisely the trap Houston designed. Now, historical analysis suggests that 10 or 15 years earlier, a more conservative court might have accepted Missouri's out-of-state scholarship as a reasonable accommodation.
What changed their minds?
By 1938, the extra-legal context was shifting. Charles Hamilton Houston and his team were demonstrating exceptional legal pedigree, commanding respect in the courtroom. Furthermore, the justices were becoming slightly more attentive to the interests of minorities, in part as a psychological reaction to the oppressive, overtly racist practices of foreign totalitarian regimes.
Like Nazi Germany.
Exactly. The rise of fascism in Europe was starting to make American elites uncomfortable with their own racial policies.
So in the 1920s and 30s, we have these small, almost reluctant cracks. The court is basically treating the most visible symptoms of Jim Crow. But as we cross into the 1940s and 50s, those small cracks are hit by a geopolitical earthquake.
A massive one.
The foundations of Jim Crow don't just crack, they begin to liquefy. And it's driven by forces completely outside the courtroom. Let's talk about the 40s and 50s.
The demographic and political landscape of the United States in 1945 was utterly unrecognizable compared to 1896. If we connect this to the bigger picture, we have to look at the Great Migration.
Millions of people moving.
Yes. Millions of Black Americans fled the violence and economic oppression of the rural South for industrial jobs in northern and western cities. This demographic shift had profound political consequences.
Because in the South, they couldn't vote.
Right. But in the North, they could.
Yeah.
Suddenly, Black Americans became a massive, highly concentrated voting bloc in swing states like Illinois, Ohio, New York, and Pennsylvania.
They became a constituency. If you were running for president, you could no longer ignore black voters because they held the keys to northern electoral votes.
It nationalized the issue of race. And as a result, between 1940 and 1952, Southern Black voter registration leaped from a mere 3% to roughly 20%.
That is a huge jump.
Driven by this new national pressure and returning Black veterans who refused to be subjugated. During this window, the Supreme Court begins striking at the actual structural pillars of white supremacy.
Right, like in Smith v.
Yes, in 1944, they struck down the white primary, which was the system that barred Black voters from participating in Democratic primary elections. And remember, those were the only elections that actually mattered in the one-party South.
Yeah, Shelley v. Kramer.
Exactly. In 1948, they ruled that state courts could not enforce racially restrictive housing covenants, which were contracts preventing homeowners from selling to Black buyers.
The thermometer is rapidly rising now. And it's not just domestic politics. The ideology of World War II plays a massive role here, doesn't it?
A completely transformative role. The United States had just sacrificed hundreds of thousands of lives fighting a global war against Nazi fascism.
A regime entirely built on the grotesque ideology of racial superiority and genetic hierarchy.
Right. It created an insurmountable cognitive dissonance for the American public. It became increasingly difficult for millions of white Americans to frame their country as the great, shining defender of global democracy, while simultaneously maintaining a rigid, violent racial caste system at home.
The hypocrisy became unbearable, not just morally, but strategically.
Precisely.
Here's where it gets really interesting, though. If you're listening and thinking this change of heart was purely a moral awakening, the history throws a massive curveball. Because right after World War II, we plunge straight into the Cold War.
Immediately into it.
The U.S. is locked in an existential global struggle against the Soviet Union. And both superpowers are vying for the allegiance of newly independent, decolonizing nations in Africa, Asia, and Latin America, the Third World.
This geopolitical reality turned Jim Crow from a regional domestic issue into an immense, acute strategic liability.
Tell us about Truman's justices. This blew my mind.
The historical record highlights a stunning fact regarding President Harry Truman's Supreme Court appointees. Justices Fred Vinson, Tom Clark, Harold Burton, and Sherman Minton.
Okay.
If you look at their broader judicial records, these four men were actually quite conservative on civil liberties. In cases involving free speech or police search and seizure, they were highly deferential to the government. They were, above all else, ardent Cold Warriors.
But on race cases,
On race cases, these conservative justices voted progressively.
Why? Did they suddenly become civil rights activists?
Not at all. They voted that way because the executive branch practically begged them to. The Justice Department under Truman began filing amicus briefs, friend of the court briefs, in civil rights cases, actively arguing against segregation.
And their argument wasn't just, hey, segregation is morally wrong, was it?
No.
The government's argument was literally, Jim Crow is destroying America's image abroad. The Soviets are plastering photographs of Southern lynchings and segregated schools all over newspapers in Africa and Asia. They are using it as propaganda to convince these new nations that American democracy is a sham. The federal government argued that segregation was a national security threat.
It was a massive PR nightmare on the global stage. The Cold War imperative for racial change was an overwhelming external political pressure. For these conservative patriotic justices, supporting racial equality claims meant supporting the federal government's foreign policy objectives in the battle against communism.
Wow.
The political axis had swung wildly. Think back to 1896. In 1896, American imperialism and national reconciliation demanded the sacrifice of black rights. 50 years later, the Cold War demanded the exact opposite.
So the court didn't change its fundamental nature. It simply responded to a completely new set of national imperatives.
Exactly. The thermometer adjusted to the new room temperature.
So the court is striking down the white primary, striking down housing covenants, forcing the desegregation of graduate schools. All these cases are basically circling the drain of the ultimate question.
The big one.
The elephant in the room that affects every single family in America. Public schools. The court had chipped away at the edges, but they were finally backed into a corner where they had to answer the question they had been dodging for decades. Which brings us, finally, to 1954. Brown v's Board of Education.
The monumental decision. In Brown, Chief Justice Earl Warren delivers the unanimous ruling that segregated public schools are inherently unequal. It explicitly overturns the doctrine established in Plessy.
It is widely considered the most important, iconic Supreme Court decision of the 20th century.
It is, but based on the analytical framework we've been using, the legal and political axes, we have to ask, why did they rule this way? Because the 14th Amendment still hadn't changed.
Right. Still the same text.
And legal precedent, built up over 60 years, heavily favored segregation. Formalistically, a judge could easily have upheld school segregation in 1954.
They ruled that way because the country had changed. When you dig into the polling data from 1954, it's incredibly revealing.
It really is. Public opinion was shifting massively. Nationwide, about half the country supported ending school segregation. But it's not just the general public that matters. It's about who the justices are and who they interact with.
We return to the concept of the justices as an elite subculture.
Yes. The demographic data surrounding the Brown decision is paramount. In 1954, polls showed that 73% of college graduates supported the Brown decision, compared to only 45% of high school dropouts.
That's a huge split.
And the justices, with their elite legal educations, Ivy League degrees, and affluent backgrounds, were situated firmly within that 73% demographic. When they went to dinner parties, when they read elite newspapers, when they talked to their peers, the consensus was clear. Segregation was an embarrassing anachronism.
They're reading the room, or at least the room of the faculty lounge and the Georgetown dinner party.
They were not acting as rogue, radical activists imposing alien values on a completely hostile nation. They were acting precisely like the cultural elites. They were heavily influenced by the changing post-war consensus among the highly educated classes.
The thermometer registered the heat of the elite consensus.
Precisely.
But here is the massive caveat to Brown that always gets glossed over in the triumphant high school history books. The 1954 ruling was a monumental declarative statement. Segregation is unconstitutional.
But they didn't actually order the schools to integrate immediately, did they?
No, they didn't. They punted the actual enforcement. The following year, in a decision known as Brown II, the court had to issue the remedy. They had to decide how and when to implement desegregation. And they used this infamous fuzzy phrase. They ordered schools to integrate with all deliberate speed.
All deliberate speed was essentially a massive political compromise and, frankly, a capitulation to reality.
Why did they do that?
The court knew that ordering immediate, overnight integration would provoke massive, violently defiant resistance in the Deep South. And the Supreme Court has no army.
Right. They can't send in troops themselves.
Exactly. As President Andrew Jackson apocryphally said, John Marshall has made his decision, now let him enforce it. The court relies on the executive branch and public willingness for enforcement. By using such an ambiguous, contradictory phrase, I mean, deliberate means slow and careful, speed means fast, they effectively permitted the South to stall.
And so they did.
The pace of desegregation in the Deep South was absolutely glacial for a decade after Brown. In many southern states, the percentage of black children attending school with white children was functionally zero well into the early 1960s.
Zero, wow.
State legislatures passed hundreds of laws to circumvent the ruling, cutting off funding to integrated schools, or even closing public school systems entirely, as they did in Prince Edward County, Virginia.
So the Supreme Court drops this bombshell ruling, takes their victory lap in the press, and then basically sits on its hands for 10 years while Southern governors physically block schoolhouse doors.
Unfortunately, yes.
What finally changed, because eventually the schools did integrate. The court finally stepped up in the mid-1960s in cases like Watson and Goss, and suddenly found their spine, declaring, okay, time's up, the time for deliberate speed is over. What forced them to act?
What changed was the civil rights movement. It wasn't legal briefs that integrated the schools, it was physical courage. In 1963 and 1964, the massive street demonstrations in Birmingham, Alabama, and elsewhere changed the calculus.
Grotesque.
Yes. These demonstrations were masterfully orchestrated to provoke a reaction, and they did. The images of police dogs attacking teenagers and high-pressure fire hoses blasting peaceful protesters were broadcast into living rooms across the nation and around the world on the evening news.
It shocked the conscience of the North.
It made civil rights the absolute, undeniable top political priority in the United States. It galvanized Northern public opinion, shaking them out of their passive sympathy and forcing the federal government to act.
So the movement forced the issue.
Only when the civil rights movement created this massive, undeniable shift in the national political landscape did the court feel it had the political cover and the institutional mandate to finally say that the era of stalling was over. The political axis shifted to the absolute extreme, demanding enforcement.
Okay, let's take a breath here. We've gone from the absolute depths of Plessy in 1896 through the horrific interwar criminal trials into the geopolitical pressures of the Cold War, up to the triumph of Brown in 1954, and finally the civil rights movement of the 1960s.
It's a long journey.
It is. We've seen how the court's interpretation of the exact same Constitution flipped 180 degrees based on the political and cultural winds. But this brings us to the final and perhaps most crucial question of this entire historical analysis. Did the Supreme Court's rulings actually change the reality on the ground? For the citizens of that era, does constitutional litigation actually drive social change?
The historical conclusion drawn from this era offers an unflinching and frankly ironic answer to that question. The grand theory of this analysis is that constitutional litigation is least likely to help those who are most desperately in need of it.
Explain that. Why is that the case?
Consider the Deep South, places like rural Mississippi or Alabama in the 1950s. Black Americans there were facing essentially totalitarian levels of oppression. They couldn't vote, they were economically terrorized, and they faced constant threat of physical violence. They couldn't simply file a lawsuit to challenge the unequal funding of their schools.
Because to file a lawsuit, you need resources. You need money to hire a lawyer. You need an actual lawyer willing to take the case, which was incredibly rare in the rural South because those lawyers would be disbarred or threatened.
Exactly.
And most importantly, you need physical safety. If you were a black farmer who filed a civil rights lawsuit in rural Mississippi in 1955, you were risking losing your bank loan, losing your job, having your house burned down, or literally losing your life.
The stakes were unimaginably high.
The people who needed the protection of the court the most couldn't even access the building.
Furthermore, the broader historical record posits that the Supreme Court rarely, if ever, supplies definitive vanguard resolutions to issues that genuinely rend the nation apart.
So they don't lead the charge.
No, the court's true functional role in American history is to suppress outliers. They only step in to forcefully mandate a policy across the board when a solid majority or a very powerful, dominant elite minority of the country has already decided it is the right path.
They don't invent the new consensus. They bring the straggling regions into line with the new consensus that has already been forged by society.
That is the core dynamic.
So was Brown v. Board useless? I mean, if it didn't immediately integrate the schools, if it couldn't help the people in rural Mississippi, and if it merely reflected what the northern elites already thought, did the ruling actually matter?
It mattered immensely, but entirely indirectly. Brown was not the engine of social change, but it was a massive, indispensable catalyst.
How so?
First, it was symbolically vital. It inspired Black Americans, providing them with the highest possible legal validation that their cause was just, breaking the psychological hold of Plessy. It helped shape the strategic agenda of the civil rights movement, shifting the focus heavily and relentlessly towards school desegregation.
Right.
But crucially, its most profound impact was that it provoked a virulent, violent white backlash in the South.
What historians call the massive resistance.
Exactly. The South radicalized in response to Brown. Politicians who were moderates were voted out, replaced by hardline segregationists who promised defiance. That violent backlash, the dogs, the fire hoses, the church bombings broadcast on television, thoroughly horrified Northern moderates.
It forced everyone to pick a side.
Yes. It was the violence of the massive resistance that created the overwhelming political momentum necessary for the political branches, Congress, and the president to finally act.
They couldn't ignore it anymore.
It forced the passage of the Civil Rights Act of 1964 and the Voting Rights Act of 1965. And it was that legislation, backed by the threat of cutting off federal funding and the physical deployment of federal registrars and troops, that truly dismantled Jim Crow.
It all comes back to that graph we started with. The legal axis and the political axis. The law absolutely matters. The text of the Constitution matters. But the law only flexes. It only truly changes reality when the political and social reality of the country demands it.
The context is everything.
The Supreme Court didn't end Jim Crow alone in a quiet marble courtroom. It took the demographic upheaval of the Great Migration, the ideological shock of World War II, the geopolitical paranoia of the Cold War, and most importantly, millions of everyday people marching in the streets, absorbing blows, to move that political axis far enough that the court had no choice but to follow.
That is the comprehensive summary of this historical journey. We've explored how the horrors of Plessy were born from a complicit imperialist nation seeking economic reconciliation at the dire expense of its Black citizens.
Yeah.
We saw how the interwar period forced the court to react to grotesque abuses of criminal procedure, stretching the law to prevent literal legal lynchings because the barbarity offended their elite sensibilities.
Right, the doctor with the dirty hands.
We examined how the geopolitical pressures of the Cold War turned Jim Crow into an unbearable national security liability. And we saw how Brown v. Board of Education was the product of an elite judicial class riding the wave of a shifting national consensus, acting as a catalyst for a movement rather than a savior.
It's an incredible, honestly sobering story of how law and society are just completely inextricably entangled. We cannot separate the Constitution from the culture that interprets it.
The core takeaway for anyone trying to understand the intersection of law and history is this. The Supreme Court is not a vanguard of social revolution. It is a mirror reflecting the dominant social, political, and cultural forces of its time.
A mirror, not an engine.
True, enduring social change does not start in the courtroom. It ends there. The court merely provides the final, validating stamp on the hard-fought victories won in the streets, in the economy, and in the culture.
You know, we started this deep dive talking about that expectation of permanence, that comforting idea that the law is an X-ray showing a clean, objective truth. But we've seen today that the Constitution is a mirror, reflecting whoever happens to be looking into it and whatever society is standing behind them at the time.
It's a powerful realization.
So I want to leave you with a final provocative thought to chew on. If the Supreme Court is merely a mirror reflecting the dominant beliefs of its era's cultural elites, look around at the settled constitutional laws of our world today. Look at the rulings that we accept right now as absolute, unquestionable, objective truths. Which of our current legal truths will future generations look back on, not as pure justice, but as a simple, transparent reflection of our present-day biases? Thank you for joining us on this deep dive.